John, great opportunity for our guests our viewers, that is, to submit their legal questions to our guest, Andrew Stoltmann. He's an attorney with Stoltmann Law, sitting next to me. How's it going, Andrew?
Going good, thank you.
Great. You're doing a great service for our viewers here. We've got 3 questions we want you to answer. You're going to be interested, I know, in the answer to these because they are interesting ones. Let's get to the first one. If a doctor writes me a prescription for medical marijuana, but my company has a zero-tolerance policy on drug use, including marijuana, could they legally fire me? Let me add here, this is all general legal advice. Of course, consult your own attorney for specific details regarding your personal case.
Well, they can fire you. Illinois, like most states, is an employee at law state. So meaning an employer can fire an employee for virtually any reason that's not discriminatory related. Now, you might think the American with Disabilities Act might preclude that because that prevents employers from discriminating based off of medical related reasons. But as of now, marijuana is still against the federal law. So your employer can fire you for medical marijuana use, even if it is for legitimate medical reasons.
And even if it's okay by the state?
Absolutely.
Federally, not okay? That's a problem. Next question. If I receive my concealed carry permit in the state of Illinois, am I legally able to carry my weapon in Wisconsin? What about Indiana?
Well, it's different in each state. In Indiana, you can carry it, but in Wisconsin, you can't. Wisconsin always does things a little bit different than other states, but you have to be real careful regardless of the state you're going in, because if you get stopped and you're carrying a weapon without the proper permit, or if it's one of the states that doesn't recognize it, you can actually go to jail for a pretty long time, so you want to be real careful.
And so important to note, because how many of us commute? We either live there, we go for the weekend to Wisconsin or Indiana. A lot of our viewers in Indiana, Wisconsin. Okay, last question here. Does a landlord have to provide 30-day notice prior to evicting you from your residence?
Well, they don't. It's actually a 5-day notice period, but what's important to remember is that it will probably take at least 30 days because once you get the notice, then you have to get served, then the landlord has to go into court and prove the case that you're not that you're basically in violation of your lease. So the entire process will take at least 30 days, and it probably takes close to 60 days.
So I think it's so important to look over that lease, right? I mean,
and nobody ever does.
Right.
Nobody ever looks at that lease until it's a little bit too late. I tell people at least spend a couple minutes looking through it, looking at some of the key points, because it's actually pretty important.
Andrew Stoltmann, thanks so much. We appreciate you being here.
Anytime,
and again,
Natalie.
Andrew giving just general legal advice for specific advice with your own case. We encourage you to consult your own attorney.